We have been receiving numerous questions regarding annulment. One of these is the query of Vina. Vina is from Ilocos Norte. She wanted to be able to live in Manila. Hence, when her boyfriend June asked her to marry him, she immediately said yes so she could bring her, or he could bring her to Manila where June works. When she arrived here in Manila, Vina discovered that she was pregnant with June. After giving birth, she immediately lived with her aunt in Quezon City. She left their child with June and just visits the baby once a week. This has been their arrangement for the past 5 years. Last year, she met an Australian dentist. Dennis asked Vina to marry him, but Vina is apprehensive about the marriage proposal because her marriage with June still subsists. She consulted a friend of hers who was in a similar predicament, but who was able to marry a foreigner after she had her marriage annulled. Her friend referred her to a person who represented himself as a lawyer. She was advised to file a petition for declaration of presumptive death, allegedly to hasten the processing of her marriage with Dennis. Vina asks whether what she advised to do or what she was advised to do was valid. Vina, you have to remember that a wrong can never be made right by another wrong. First, you should not have entered into a marriage just so you can go to Manila. Second, you have to remember that in our law, marriage is looked upon with sanctity as it is the root of the family, which the law considers as a basic social institution. Third, you have to remember that you cannot simply erase your marriage with June by making it appear that he is already deceased for the reason that you want to marry another person. According to Article 41 of the Family Code, a marriage contracted by any person during the existence of a previous marriage shall be null and void unless, before the celebration of the subsequent marriage, the prior spouse had been absent for 4 consecutive years and the spouse present has a well-founded belief that the absent spouse was already dead in case of disappearance, where there is danger of death, an absence of only 2 years shall be sufficient. Based on your narration, Vina, it is clear that June is still very much alive and is taking care of your child. In fact, you still visit them once a week. If you would insist on filing a petition for declaration of June's presumptive death, there is a high probability that it will just be denied for lack of any legal ground. You may file a petition for annulment of marriage, but remember that it has to have all the valid grounds and requisites in order for it to be granted. Be careful, too, of people who pretend to be lawyers. We hope that we have sufficiently answered your queries. Please email us at ptv4newscenter@gmail.com. This is Attorney JJ Jimeno Atienza for the Rule of Law.